Hello gorgeous people, my name is Hayley Boud, founder of The Caring Lawyer. I work as a relationship property lawyer in Hamilton at Gurnell Harrison Stanley Law. I specialise in contracting out agreements, which is why I like to say that I help new lovers protect their assets. Now today's question is, what is economic disparity? If you are about to sign a contracting out agreement, or as some people call it, a prenup, then I recommend carefully reading the prenup to see if it mentions anything about economic disparity. If it does, it is very likely that it is a clause saying that neither you nor your partner will bring a claim for economic disparity should your relationship end. If it does have that clause, I strongly recommend asking your lawyer more about this and asking whether it is actually appropriate in your circumstances. Now today I'm going to give a brief explanation of what economic disparity is, just so you can have an idea. This is just to give you an idea. And I'll give you an idea of what your rights are under the relationship property law in New Zealand. But this is really only to give you an idea. This is not legal advice, and I strongly recommend talking to your lawyer. Ask your lawyer more about this clause before you sign the prenup, because you could be disadvantaged by signing the prenup if your relationship did end, depending on your circumstances. So it might be entirely appropriate for your circumstances, but definitely talk to your lawyer about it. But today I will give you a brief overview. What is economic disparity? What does it mean? And your rights under the law. But that's it. It's just a brief overview. So Section 15 of the Property Relationships Act, and from this point on, I'll just call it the Act. It's in that clause, section, it says a court can make a lump sum award or transfer property to one partner if the court is satisfied. Now, there are a few things that they have to be satisfied on, and one of them is the likely earning capacity and standard of living is significantly different between the two. And the cause of the difference is a result of division of functions within the relationship. So you've got those two things going on there. There is a difference in what you're earning, and the difference is was caused by a division in your roles in the relationship. Now, for example, the husband stays home, takes care of the kids, while the wife goes off to work. You've got now a division of functions. And by doing this, the husband's career is taken off. The husband's staying home. The husband's career is put on hold while the wife's career is taking off. Now, after many years, the wife now is in a much better financial position because her career is taken off than the husband, because his career has stayed the same or maybe even gone down because of spending so much time at home with the children. And this is at no fault of the husband, it's something they've decided together. The husband has sacrificed his career for the family, but is now disadvantaged when the relationship ends. When that happens, the court can compensate the husband for this disadvantage, which is actually a really good thing. In deciding whether to make such an order, the court will have regard to the likely earning capacity of each partner. So that's one thing, the likely earning capacity of each partner. And then they'll also look at the responsibility of each partner for the ongoing daily care of any dependent children of the relationship. So if you've put your career on hold, their career's taken off, and because you're looking after children, and going forward you'll still be looking after children, those are the things they look at. And they also look at any other relevant circumstances. And this is to compensate for the different earning capacities of the partners that was caused by the division of functions within the relationship. There's a very famous case, Scott and Williams, 2017, and it went to the Supreme Court. And it was held that Section 15's causation requirement, this is what the judge said, seems to me to be a broad one, in the sense that where a relationship has been conducted along traditional lines and there is a disparity of income and living standards post-separation, it should be assumed that the division of responsibilities in the relationship should be assumed that the division of responsibilities in the relationship was for the benefit of both partners. So that if you have been looking after children, that was for both your benefit and for your partner's benefit. You both benefited from that. And it should be assumed, the judge said, that restricting the non-partner's income earning ability. So by staying home, it restricted their ability, or your ability, if you were the one who stayed home, to be able to earn income. The mere fact of staying home restricted that. That's to be assumed. And it's also to be assumed that it enhanced, by you staying home, it enhanced the career partner's earning ability. Because they were able to continue working. So, they continued to get those pay increases every year and get new job titles. So although there is a presumption of economic disparity where one partner has stayed home to take care of children and the other has continued working, courts will still be reluctant to grant an award if there is no evidence to establish that the enhanced income is a result of the division of functions within the relationship. The one bringing an economic disparity claim needs to provide evidence that their earning capacity either remained the same or decreased due to being a stay-at-home parent, while the ex-partners increased by being able to continue to work on their career. Where the higher earning partner's earning capacity reflects his or her qualifications or their experience or their abilities, then causation is not established. If it's because the partner was, they're a lawyer and you're not, then that's not the causation. The causation has to be because you stayed home and took care of the kids. But if the division of functions permitted the higher earning partner to apply him or herself to an extra degree, or to apply himself to his career and his career took off because of you staying home, then causation for income enhancement will be made out. In the case I mentioned before, Scott and Williams, Section 15 is not a rules-based provision. That's what they said in that court. And that's important to note. It's not a rules-based provision, but rather it gives a broad discretion with very little guidance, actually, as to how it is to be exercised. The court said in that case, moreover, both parties to a relationship must be left in a position that allows them to move on with their lives. As a result, the amount of compensation that can be awarded will often be comparatively modest. This case that I just talked about is the leading case in New Zealand on this topic because it was in the highest court of New Zealand. So we have to listen quite carefully to this case, even though it can be quite hard to understand it. But basically the court is saying that there is little guidance in the Act itself on how to exercise an award for economic disparity. But should compensation be awarded, the amount should be an amount that leaves both in a position to be able to move forward. This means that the compensation shouldn't be excessive. It should be an amount that helps both to move forward. Also, in that same case, the court held that an award must be just and cannot create an injustice for the higher earning party. So it shouldn't be such a huge amount that that high earning party is now in a worse off position. Case law in New Zealand shows that there actually is no one method, no one formula or approach that can be applied to calculating an economic disparity order. And that's because there is no single way to prescribe what is just. This will depend on the individual circumstances of each relationship and each partner. However, generally speaking, courts will look at the following to determine an amount to award. So what they will look at is the difference between the two partners' earning capacity after tax. So they'll look at what you earn, what he or she earns, and then they'll look at the number of years it would take for the lower earning partner to gain parity with that higher earning partner. And then they also take into consideration contingencies, such as that higher earning partner being made redundant or becoming too sick to actually be able to work. So they usually take off maybe 25%, sometimes up to 35% for those contingencies. In one case called B&B in 2004, there was an approximate $8,000 difference in yearly income, and this was enough to satisfy the test. Upon division of the relationship property, both partners had enough capital to be able to purchase a home, and both provided equal childcare. But the husband earned $45,000 and the wife earned $37,000. The amount that the wife could earn was likely to increase to a point where it would be equal to the husband. So the wife was awarded a lump sum payment of $16,000. In another case, C&C, it's called, the wife provided evidence that the husband's post-separation income was $200,000 per annum, and hers at the time of separating was $15,000. The wife showed that she had previously earned $50,000 per year prior to giving birth to their first child. So you can see that it's obvious that her income capacity was a lot lower than what it was before the relationship and a lot lower than his. But at the time of the court hearing, because it takes a while to go through court, her earning was $72,000 per year. So still more than half of what he's earning. The court determined that it would likely take the wife 6 years to regain the parity she would have had but for the decision to take care of children. The wife was awarded $50,000. So this sort of shows you what kind of awards would be given if successful. But it's not certain that you would be successful, and it's never really sure. So if you are about to sign a contracting out agreement and it has a clause regarding economic disparity, ask your lawyer if this is appropriate in your circumstances. If you are a stay-at-home parent, putting your career on hold while your partner's career is taking off, and the prenup states that you will not bring a claim for economic disparity, it may not actually be recommended for you to sign such a prenup. It may be recommended to remove that clause. The rest of the agreement may actually be fine. But this is something that you should definitely talk to your lawyer about, because having such a clause in the agreement could really disadvantage you should your relationship end in the future. If you want to know more about economic disparity, or if you have any other relationship property questions, feel free to give me a call. My number is 07 839 7632. You can find that by Googling, but again, 07 839 7632, or you can email me on Hayley, my name Hayley, at ghslaw.co.nz. Again, Google it, but it's Hayley at ghslaw.co.nz. Thanks again, guys, for listening. I hope that was informative. Feel free to, just ask some more questions if you have any. Thanks. Bye.